G'day everyone, and welcome to the second video in week 7 of our admin law course. This week we're looking at the grounds for review which occur when the decision maker has the power to make the decision, but they make an error when they're doing so. In the first video we looked at an error of law where the decision maker misunderstands the actual law that they're meant to be applying. In this second video we're going to look at evidence. Before we look at the rules though, there are a couple of important things to understand. First up, even though we use the word evidence, the rules of evidence do not apply in administrative decision making. This was confirmed in a case called Irving against the Minister for Immigration. Now, some of you may not yet have completed your evidence subject, but those of you who have, an administrative decision maker is not required to consider admissibility rules at all. They can consider hearsay, they can consider opinion. Often the vast majority of their evidence will be documentary, and none of the rules about the admissibility of documents will apply. So when thinking about administrative decisions, put aside the rules of evidence. Second, remember that the hearing rule of natural justice will apply to all of these decisions. So subject to the restrictions we discussed back in week 5, all of the evidence which was relied on by the decision maker should be shown to the person affected by the decision. Okay, so what are the evidential grounds on which a decision can be challenged? First up, Section 5.2a of the ADJR Act says that a decision maker must not take an irrelevant consideration into account. And then Section 5.2b says that a decision maker must take into account all of the relevant evidence. Those two requirements dovetail together quite nicely. The decision maker must ignore any irrelevant evidence and must take into account any relevant evidence, which means they can't just conveniently ignore evidence which goes against the decision that they intend to make. Naturally, the next question is, what do we mean by relevant? Now, I've just said that the rules of evidence don't apply to administrative decision making, and that's true. But there's still some useful stuff in evidence law which can help us, and one of those things is the definition of relevant. In evidence law, evidence is relevant if it is logically capable of affecting the likelihood that a fact in issue is more or less true. So to be relevant, something doesn't have to be a golden bullet. All it needs is to be logically capable of moving the decision maker's mind in one direction or another. So let's imagine that our decision maker is inspecting the logbook of a young person. Now the rules say that at least 10 hours must be completed while driving at night. The decision maker notices that a lot of the claimed night driving hours are between 5 p.m. and 6 p.m. So the decision maker pulls up the Bureau of Meteorology pages to check the sunrise and sunset times on those days. Can you see how this is relevant information? It affects the likelihood of the decision maker deciding that the minimum number of night driving hours has been completed. On the other hand, let's imagine that our decision maker held the view that fathers were not great driving supervisors. That might well be true. But let's say the decision maker decides to ignore any driving hours where the father was the supervisor. Can you see how this would be taking into account an irrelevant consideration? Most of the forms of discrimination, gender, age, sexuality, race, are irrelevant considerations for most decisions. Relevant and irrelevant considerations also vary from decision to decision. The disability status of a person would be irrelevant to their application for registration as a teacher, but absolutely relevant to their application for funding under the National Disability Insurance Scheme. The race of a person would be irrelevant to their entitlement to a driver's licence, but very relevant to their entitlement to participate in an Indigenous employment scheme. If a decision maker refuses to consider relevant evidence, or if they take into account irrelevant evidence, then their decision is invalid. The thing is though, all they have to do is take some account of relevant material. Two cases, one called Our Town FM against the Australian Broadcasting Tribunal and another one called the Minister for Aboriginal Affairs against Peko-Wallsend, both made it clear that the bar is low. We are entitled to expect decision makers to take some account of relevant evidence. But if they attach less weight to that evidence than we would like, well, there's no error in the decision-making process. In the Our Town case, the holders of a radio licence were objecting to the granting of a new radio licence for an additional competitor station. They claimed that the tribunal had not considered the evidence of the concentration of ownership of media in the area if a pre-existing operation added an additional licence. Now, the court found that these criticisms were very valid. There was clearly a lot of sympathy in the court for the position being held by Our Town, but the tribunal had given some consideration to the issue of concentration of ownership, and that was enough, so the decision was not invalid. The second big rule relating to evidence is found in section 5(1)(h) of the ADJR Act. A decision can be reviewed if there was no evidence or other material to justify the making of the decision. Now, this rule completely bamboozles many students for good reasons. I'll try to make some sense of it. It helps to think of this as the rule which operates if there's been a big mistake about the meaning of the evidence. If I say to the decision maker, I have a driver's licence, but they misunderstand me and they believe I was saying I have a motorcycle licence, then their conclusion that I was entitled to ride a motorcycle would be invalid because there would be no evidence to support it. They just simply thoroughly misunderstood the evidence. Let's look at a real life example. In the Minister for Immigration against al-Miahi, the Refugee Review Tribunal refused to accept that Mr. al-Miahi was from Iraq. Their reasoning was that he had claimed in an interview to be from the city of al-Amara, but he was unable to tell them much about the city. Some of his other statements seemed to conflict with the idea of him being from al-Amara. In fact, though, it turned out that he had never claimed to be from al-Amara. He had actually claimed to be from a much smaller place called Ali Ash-Shaki. Now, you can see that if the tribunal had refused his visa because they didn't believe his claim of living in al-Amara, the decision would have been invalid. You can't make a decision against someone's interests on the basis that they made a statement that they never actually made. In this particular case, even though this fact was wrong, there were other reasons not to grant the visa, and so the court found against Mr. al-Miahi. Can you see the way the rule works, though? If a certain fact is crucial to the decision, and it turns out that fact is wrong, well, there's no basis for the decision. Generally speaking, in a no evidence situation, there's not going to be any need to take action in a court or tribunal. When it's pointed out that the decision maker has fundamentally misunderstood the evidence, they'll often just back away from the decision and change it. Here's the bamboozling bit. Back before the ADJR Act was introduced, there was a common law rule, which was also called the no evidence rule, but it was quite different. Remember how last week we talked about the fact that sometimes the existence of certain facts is a precondition for the decision being made? Well, the old school common law no evidence rule said that if there was no evidence of those preconditions being met, the decision could not proceed. Completely different to the modern rule. So if you read really old cases and they mention the no evidence rule, you're actually reading about a completely different rule. You'll tie yourself into knots. Okay, so that's the end of the second video. We now know that a decision is reviewable if it's affected by an error of law. We know that decision makers must take into account all of the relevant material and none of the irrelevant material. And we know that a decision is invalid if there's no evidence of a key fact which the decision maker has relied on. In the next video, we're going over to the dark side. We're going to look at those decisions that are invalid because of improper behaviour by the decision maker. 3 to go.